Of late, we have seen there's a lot of discussion on the social media in respect of juvenile justice system. And the offshoot is as to whether the childcare institutions are truly reformative under the juvenile justice system. Are there certain way forwards where it can improve, or the intent for which they were made is actually being achieved in the right perspective and manner? This is the particular landscape on which Dr. Deepa Singh, an advocate from Punjab Haryana High Court, would be taking us through. And I'm quite sure that the colors which she will fill on the landscape will actually help you to understand this perspective in the right manner, which will help you to facilitate not only as a lawyer, professional, a judge, or a common person. As usual, like we have already seen, that Dr. Deepa Singh takes his session with a blend of Hindi and English. So we have requested her to take the session in that normal mode. And over to you, Dr. Deepa, and we are glad that you are on the board. Over to you.
Thank you, Vikas, for giving me this opportunity. And uh, and this topic is actually very close to my heart because in my opinion, it's the best, ever drafted legislation. It is drafted in such a beautiful, simple language that, a law graduate, fresh graduate can understand it. So the main topic is childcare institutions. But before we discuss the functioning of childcare institution or whether they are able to achieve the object under this act, we need to, understand the structure of this juvenile justice care and protection. So the preamble is itself is very beautifully says an act to consolidate and amend the law relating to children alleged and found to be in conflict with the law and children in need of care and protection by catering to their basic needs through proper care, protection, development, treatment, social reintegration by adopting a child friendly approach in the adjudication and disposal of matters in the best interest of children and for their rehabilitation through processes provided and institutions and bodies established herein under and for matters connected therewith or incidental thereto. So, in the whole Juvenile Justice Care and Protection of Children Act 2015 में हम लोग देखेंगे कि बहुत सारी जो है ना इसमें इंस्टीट्यूशंस की बात की गई है, बहुत सारी अथॉरिटीज की बात की गई है एंड बहुत सारे जो है कैटेगरीज ऑफ चिल्ड्रन की बात की गई है. सो सबसे पहले इसमें हम देखते हैं कि किन लोगों के लिए, किन बच्चों के लिए ये एक्ट आया. तो इसमें 4-5 कैटेगरीज हैं. सबसे पहले तो दिस एक्ट डिफाइंस हु इज अ चाइल्ड and everyone knows who is below the age of 18, it's a child. Now it further categorizes this child into two categories: child in conflict with law and child in need of care and protection. So apart from these two child, it talks about the orphan, surrendered child, and abandoned child also. So at times we just only aware that के जे एक्ट जो है वो उन बच्चों के बारे में बात करता है जिनसे कोई अपराध हो जाता है या फिर उनको चाइल्ड वेलफेयर कमेटी के बारे तक में पता है, लेकिन दिस एक्ट प्रोवाइड्स provisions for adoption also. So usually बहुत ज्यादा लोगों को नहीं पता है कि जो अडॉप्शन के बारे में, चाइल्ड को अगर हमने अडॉप्ट करना है तो कहाँ हमें जाना है, कौन कौन सी प्रोसीजर को अडॉप्ट करना है, कौन सी प्रॉपर एजेंसीज हैं. तो अगर जनरल आप पूछें तो सब यही बोलेंगे कि हिंदू माइनर अडॉप्शन मेंटेनेंस एक्ट वगैरह, बट नहीं, दैट इज एप्लीकेबल ओनली ऑन हिंदू child. But what about orphan children? abandoned children, and surrendered children. So we'll be discussing a bit of that area also, because it talks about intra-country adoption also. So these are the major thing, benefit of children. Now, who are the authorities? Board, Juvenile Justice Board, Police Welfare, Child Welfare Officer, Child Welfare Committee, and Special Juvenile Police Units. So, a children's court. So, these are various authorities, agencies, and institution के अगर हम बात करें तो there are various institutes mentioned in this act. उसको समझना बहुत बहुत ज्यादा जरूरी है. So I'll name few institutions. First, children home, open shelter, observation home, special home, place of safety, specialized adoption agency, and fit facilities. So these are the various institutions. So इसमें मैंने देखा कि institutions इतने ज्यादा हैं तो लोगों को थोड़ा सा कंफ्यूजन हो जाता है कि ओके, चिल्ड्रन होम में कौन जाएगा, ओपन शेल्टर में क्या होगा, ऑब्जर्वेशन होम की कब जरूरत पड़ेगी, स्पेशल होम क्या है, प्लेस ऑफ सेफ्टी क्या है, स्पेशलाइज्ड एडॉप्शन एजेंसीज क्या है, एंड अगेन दैट फिट फैसिलिटीज क्या है. So, after this few basic principles, I'll discuss that what is the base, what are the principles which needs to be followed while dealing with the all children under this act. So, as the short title, extent, commencement, and application, section 1 says, I am reading the section, subsection 4. Notwithstanding anything contained in any other law for the time being in force, the provision of this act shall apply to all matters concerning children in need of care and protection and children in conflict with law, including apprehension, detention, prosecution, penalty, or imprisonment, rehabilitation, and restoration of children in need of care and protection. Now, the section 3 is very important. It talks about 16 general principles, and these principles are applicable on all the authorities dealing with the child. So whether it's a board, it's a police officers, committee, or judges, etc. So the general principles to be followed in administration of the act. The first principle, which is common also in criminal jurisprudence, principle of presumption of innocence, principle of dignity and worth, principle of participation, principle of best interest. This is very important. It says that all decisions regarding the child shall be based on the primary consideration that they are in the best interest of the child and to help the child to develop full potential. Even when the bail is a right to a juvenile, but in case the board is not inclined to grant him bail, then that reason also be recorded that it is not in the best interest of the child. So everywhere, whenever whatever order is being passed for the child, it should be based on this principle of best interest, principle of family responsibility, principle of safety, positive measures, and principle of non-stigmatizing semantics. If you read this act, you will notice that this uh, act takes care that no harsh words are being used. For example, when we talk about trial, it says inquiry. When we talk about FIR, there is an SIR. If in case there is a sentence, judgment, we don't call it sentence or judgment, we call it order. So
Just hold on.
various
Probably,
various
yeah.
various measures have been taken that non-stigmatizing semantics, adversarial or accusatory words are not to be used in the processes pertaining to a child. Because when JJ Act was came into 2000, then they used to use this term delinquent child and postal jail. So those words are also amended in the further amendment. So this is very, very important that no accusatory words are to be used. Principle of non waiver of rights. No waiver of any of the right of the child is permissible or valid, whether sought by the child or person acting on behalf of the child or a board or committee, and any non exercise of a fundamental right shall not amount to waiver. Principle of equality and non-discrimination, principle of right of privacy and confidentiality. This is also very important. Every child shall have a right to protection of his privacy and confidentiality by all means and throughout the judicial processes. So there is a prohibition that child's identity and any proceedings with regard to juvenile should not be, published in the newspaper. Principle of institutionalization as a measure of last resort. This is one of my favorite principle out of all these 16 principles. And you will also notice that this act specifically takes care that इंस्टीट्यूशनलाइज जो है उसको बहुत ही लास्ट में किया जाएगा। सबसे पहले बहुत सारे तरीके हैं उसको एडमोनिशन के, उसको कम्युनिटी सर्विस, उसको थेरेपीज प्रोवाइड करने के, स्कूल जाने के, वोकेशनल ट्रेनिंग के। सो इंस्टीट्यूशनलाइजेशन जो होगा उसका बिल्कुल लास्ट में होगा। A child shall be placed in institutional care as a step of last resort after making a reasonable inquiry. Principle of repatriation and restoration. Every child in the juvenile justice system shall have the right to be reunited with his family at the earliest and to the restored to the same socio-economic and cultural status that he was in before coming under the purview of this act, unless such restoration and repatriation is not in the best interest. So the effort under this act should be that the child should be placed with the family. Hello?
Yeah.
Something went wrong?
No, no. In fact, some people getting themselves unmuted, therefore there was noise. I have muted all.
Okay, okay, okay.
So it was
So,
disturbing the entire scene.
all right. So, principle of fresh start. And this principle has been really taken care under this act that the juvenile should be able to start his or her life afresh. All past record of any child under the juvenile justice system should be erased, exceptional in special circumstances. Principle of diversion. Measures for dealing with child in conflict with law without resorting to judicial proceedings shall be promoted unless it is in the best interest of the child or the society as a whole. Principle of natural justice, last principle. Basic procedural standard of fairness shall be adhered to, including the right to a fair hearing, rule against bias, and the right to review by all person or bodies acting in a judicial capacity under this act. So these 16 principles are very, very important while dealing with the child, whether he's child in conflict with the law or child in need of care and protection. So now these are the basic principles. Now I would like to read few definitions where the you will have to know the distinction between child, child in need of care and protection, and who is a child in conflict with law. So the section 2, subsection 12 defines child. Child means a person who has not completed 18 years of age. And who is child in conflict with the law means a child who is alleged or found to have committed an offense and who has not completed 18 years of age on the date of commission of such offense. सो इसको पूरा पढ़ना है इस डेफिनेशन को, और फिर उसके बाद कभी कोई कंफ्यूजन होगा ही नहीं कि बहुत सारी क्वेरीज आती हैं कई बार के when the crime was committed at that age he was juvenile, but during the pendency of inquiry or maybe he was apprehended after so many years, it meanwhile he has attained majority, then what will happen? So the principle, the section 12 or the 13 makes it very clear. Child in conflict with the law means a child. The deciding factor would be age on the date of commission of such offense. If he or she is a juvenile on the date of commission of such offenses, for the rest of the proceedings, he will be treated as a juvenile child in conflict with law. Now, who is a child in need of care and protection? It provides 12 categories of जिनको short में हम बोल देते हैं CNCP. Child in need of care and protection. As the name is very, very suggestive, first, who is found without any home, who is found working in contravention of labor laws, who resides with a person whether guardian of the child or not, and such person injured, exploited, abused, or neglected the child, or violated any other law for the time being in force meant for the protection of child, has threatened to kill, injure, exploit, has killed, abused, neglected, or exploited some other child or children, and there's a reasonable likelihood of the child in question being killed, abused, or exploited, who is mentally ill or mentally or physically challenged or suffering from terminal or incurable disease and having no one to support or look after or having parents, or who is a parent or guardian, and such parent or guardian is found to be unfit or incapacitated by the committee or the board to care and protect the safety and well-being of the child, who does not have parents and no one is willing to take care and protect, or who is abandoned or surrendered, who is missing or runaway child, and or whose parents cannot be found after making reasonable inquiry in such manner as may be prescribed, or who has been or is being or likely to be abused, tortured, or exploited for the purpose of sexual abuse or illegal act, or who is found vulnerable and inducted into drug abuse or trafficking, or who is being or likely to be abused for unconscionable gain, or lastly, who is victim or affected by any armed conflict, civil unrest, or natural calamity, or who is at imminent risk of marriage, being attained the age of marriage, and whose parents, family member, guardian, and any other person are likely to be responsible for solemnization of such marriage. So there are 12 categories of child in need of care and protection. Now, there is another category may appear at times. A child who is below the age of 18, he is also a child in conflict with the law, and at the same time he is also child in need of care and protection. So there are various categories carved out under this act, but uska procedure ab कैसे होने वाला है. And I must tell you that these authorities are formed under the this department has specially come under the women and child uh, department, women and child department. And now, what are the institutions? बिकॉज बहुत बहुत कंफ्यूजन कई बार हो जाता है कि व्हेन द जुवेनाइल इज फेसिंग इंक्वायरी, तब उसको कहाँ रखा जाएगा. अगर इंक्वायरी में ये पाया जाता है कि उसने कुछ किया है कॉन्फ्लिक्ट विद लॉ में, वो एक्चुअली में इन्वॉल्व था, फिर उसको कहाँ भेजेंगे. और क्योंकि मैक्सिमम उसको 3 इयर्स के लिए भेजा जा सकता है, तो अब वो 3 इयर्स के बाद एडल्ट हो गया है, तब उसको कहाँ भेजा जाएगा. तो ये इसको बहुत ध्यान से आ, समझना है आपको कि सबसे पहले हम बात करते हैं ऑब्जर्वेशन होम की. ऑब्जर्वेशन होम अगेन इसमें बहुत बहुत सिंपल सजेस्टिव है. केस ऑब्जर्वेशन होम को कैसे याद रखना है, अपने स्पेशल होम को कैसे याद रखना है, प्लेस ऑफ सेफ्टी को कैसे याद रखना है. Observation home means an observation home established and maintained in every district or group of district by state government, either by itself or through a voluntary or non-governmental organization, and is registered as such for the purposes specified in subsection 1 of section 47 for the temporary reception of the juvenile in conflict with law. Temporary reception means when there is a inquiry being conducted by the board. So जब तक board inquiry conduct करेगा, तब तक juvenile in conflict with law or child in conflict with law will remain in observation home if he has not been released on bail. Now there is a special home. Special home means an institution established by state government, voluntary, non-governmental organization registered for housing and providing rehabilitative services to children in conflict with law who are found through inquiry to have committed an offense and are sent to such institution by an order of the board. So once the inquiry is finalized, comes to an end, and it is found that he was actually committed an offense, then he should be sent to special home for rehabilitation services, for for other reforms, so he can be reformed and reunited with the family or the society. Now there is another place of safety. प्लेस ऑफ सेफ्टी को थोड़ा सा समझना मुश्किल है. प्लेस ऑफ सेफ्टी बेसिकली उस सिचुएशन को कवर करता है जब juvenile is the child is above the age of 16, below the age of 18, has committed heinous offense. So it is not advisable that that child should be kept among all the children who is facing inquiry under petty offenses or senior serious offenses. So then in that case, during the inquiry also, and after the conflict, after the inquiry is finalized, that child above 16, below 18 should be sent to the place of safety. So, place of safety means any place or institution not being a police lockup or jail established separately or attached to, separate भी हो सकती है और observation के साथ attached भी हो सकती है और special home के साथ भी attached हो सकती है, to receive and take care of the children alleged or found to be in conflict with law by an order of the board or the children's court, both during inquiry and ongoing rehabilitation after having been found guilty for a period and purpose as specified in the order. So observation home, special home, and place of safety. Now, this act makes a category of offenses also. In CRPC, there is a schedule one which defines all the offenses, bailable, non-bailable, and punishment, and tribal by which court. So the CRPC would not be applicable. The beauty of this act is that it has categorized offenses into three categories depending upon the punishment: petty, serious, and heinous offenses. What are the petty offenses? Up to 3 years. Serious offenses, 3 to 7, and heinous offenses is 7 and above. So, and one more thing, because the act is very, very elaborate. So, मैं इसको थोड़ा सा शॉर्ट में बता देती हूँ कि प्रोसीजर कौन सा एप्लीकेबल होगा. If it is a petty offense, then summary trial में जो हम procedure adopt करते हैं, that would be applicable. In serious offenses, summon case वाला होगा. Even heinous offenses में भी procedure वही होगा, summon case वाला. Meaning thereby, इसका मतलब क्या हुआ, इसका पर्पस क्या हुआ कि मैंडेटरी फ्रेमिंग ऑफ चार्ज नहीं है. चार्जेस मैंडेटरी फ्रेम नहीं करना, 313 की रिक्वायरमेंट इसमें फिर नहीं होती. जस्ट नोटिस ऑफ एक्यूजेशन एंड उसका एक्सप्लेनेशन, दैट्स इट. सो एज वी हैव डिस्कस अर्लियर, इसमें ट्रायल प्रोसीजर बहुत बहुत ही, ट्रायल तो हम बोलते ही नहीं है, बट बहुत ही डिफरेंट तरीके से इसमें इंक्वायरी को कंडक्ट किया जाता है. जस्ट ये इस पर्पस के लिए कि वेदर उसने वो ऑफेंस किया है या नहीं किया. जुवेनाइल जस्टिस बोर्ड के बारे में हम सबको पता ही है कि जुवेनाइल जस्टिस बोर्ड कॉन्स्टिट्यूट होता है, कोर्ट कैंपस अलग होता है, प्रेमिसेस अलग होते हैं, एंड देयर इज अ प्रिजाइडिंग ऑफिसर एंड वन सोशल मेंबर, देयर इज अनदर मेंबर, 3 मेंबर्स का बोर्ड होता है. सो उसको मैं नहीं डिस्कस कर रही, बट व्हाट इज इंपॉर्टेंट इज सेक्शन 5 and section 6. I'll be discussing only the relevant and very important sections. Section 5 says placement of person who ceased to be a child during process of inquiry. It says where an inquiry has been initiated in respect of any child under this act, and during the course of such inquiry, the child completes the age of 18, then, notwithstanding anything contained in this act or in any other law for the time being in force, the inquiry may be continued by the board, and order may be passed in respect of such person as if such person has continued to be a child. Then section 6 is also important. Placement of person who committed an offense when person was below the age of 18. Any person who has completed 18 years of age and is apprehended for committing an offense when he was below the age of 18 years, then such person shall, subject to the provision of this section, be treated as a child during the process of inquiry, and the person referred to in subsection 1, if not released on bail by the board, shall be placed in a place of safety during the process of inquiry, and the person referred to in subsection 1 shall be treated as per the procedure specified under the provision of this act. So again, summing up together all the sections and definition, there's no confusion. If the child is a juvenile during the inquiry, we know the procedure. But if he is attained majority, and but he was a child in conflict with law at the date of commission of offense, he will be treated as child in conflict with law. But if we all know that he's attained the age of 18, but he should be kept in place of safety till he attains the age of 21 years. And if he has to undergo further order of the board or children's court, then after completion of 21 years, he should be sent to the jail. So these are various institutions, and we have discussed that what will happen if the child attains majority during the pendency of inquiry and uska placement kahan pe hoga. Now, then there is a section 9, also very, very important, that कि जुबनलिटी की प्ली कब ले सकते हैं कब नहीं ले सकते. फॉर एग्जाम्पल किसी का से ट्रायल या इंक्वायरी ट्रायल कंडक्ट हो गया एंड it's found later that he was juvenile at the date of commission of the crime. So what should be done in that situation? Section 9, procedure to be followed by magistrate who has not been empowered under this act. When a magistrate not empowered to exercise the power of the board under this act is of the opinion the person alleged to have committed the offense and brought before him is a child, he shall without any delay record such opinion and forward the child immediately along with the record of such proceeding to the board having jurisdiction. Now, section 2 is very important. In case a person alleged to have committed an offense claims before a court other than a board that the person is a child or was a child on the date of commission of the offense, or if the court itself is of the opinion that the person was a child on the date of commission of the offense, the said court shall make an inquiry, take such evidence as may be necessary to determine the age of such person and shall record a finding on the matter stating the age of the person as nearly as may be, provided that such a claim may be raised before any court at the appellate stage also, and it shall be recognized at any stage even after final disposal of the case, and such a claim shall be determined in accordance with the provisions contained in this act and the rules made thereunder, even if the person has ceased to be child on or before the date of commencement of this act. And if the court finds that a person has committed an offense and was a child on the date of commission of such offense, it shall forward the child to the board for passing appropriate orders, and the sentence, if any, passed by the court shall be deemed to have no effect. In case a person under this section is required to be kept in protective custody while the person's claim of being a child is being inquired into, such person may be placed in the intervening period in a place of safety. So that any person who was a child in need of child in conflict with law, but now he has attained majority, shall not be kept with the other juvenile in either in observation home or in special home. He should be placed in place of safety. So now we have discussed various institutions, various categories of child. Now, what should be the procedure if a child is in conflict with law, is apprehended, or information is received by the police officer? So, we'll notice that role of police is very, very negligible. And in every state, there is a special juvenile police unit and a child welfare officer. And no officer should wear the uniform, and usko जेल में और पुलिस लॉकअप में हैंडकफिंग, एग्रेसिव इंटेरोगेशन और ये सारी चीजें नहीं होंगी इसमें. तो सेक्शन 10 इज इंपॉर्टेंट अगेन. As soon as child alleged to be in conflict with law is apprehended by the police, such child shall be placed under the charge of the special juvenile police unit or the designated child welfare police officer, who shall produce the child before the board without any loss of time, but within a period of 24 hours of apprehending the child, excluding the time necessary for the journey and from the place where such child was apprehended. So, provided that in no case a child alleged to be in conflict with law shall be placed in police lockup or lodged in a jail. And the child alleged to be in conflict with law may be sent to an observation home or place of safety according to the age bracket as the case may be. And further, it, put certain obligation on the authorities who is for the time being in charge of that juvenile in conflict with law. As per section 11, all person in whose charge a child in conflict with law is placed shall, while the order is in force, have responsibility of the said child as if the said person was the child's parent and responsible for the child's maintenance. Now, coming to the next important section, bail. Bail to a person who is apparently a child alleged to be in conflict with law. So it is mandatory that he should be released on bail with or without surety. अगर 7 डेज तक वो अपने बॉन्ड्स नहीं भरता तो इसको फिर से बोर्ड के सामने पेश किया जाएगा और उसकी मॉडिफिकेशन हो जाएगी. बट अगर उसकी bail nahi honi, for example, then there's mandatory that provided that such person shall not be released if there appears reasonable grounds for believing that the release is likely to bring that person into association with any known criminal or expose the said person to moral, physical, or psychological danger, or the person's release would defeat the end of justice, and board shall record the reason for denying the bail and circumstances that led to such a decision. So again, the as per section third 3, I discussed 16 principles. So this is again reflecting that principle. If the bail is denied, it should be again in the interest of best interest of the child. And then, as per section 13, information to parents, guardian, or probation officer. This is not. Now I'm coming to the significant sections, section 14, 15, and 18. As per section 14, there's a time limit that if it is petty offense, the inquiry should be conducted, should be completed within 4 months and maximum 2 months ka extension milega. After that, if inquiry is not concluded, then automatically proceeding shall stand terminated. Right? Now, the board, this is with regard to the petty offenses. And now the serious offenses, uh, there is a provided that for serious or heinous offenses, in case the board requires further extension of time for completion of inquiry, the same shall be granted by the CGM or, as the case may be, CGM for reasons to be recorded in writing. At the time of initiating the inquiry, the board shall satisfy itself that child in conflict with law has not been subjected to any ill treatment by the police. In all cases, the proceeding shall be conducted in simple manner as possible, and care shall be taken to ensure that the child against whom the proceedings have been initiated is given child-friendly atmosphere during the proceedings. And every child brought before the board shall be given the opportunity of being heard and participate in the inquiry, and cases of petty offences shall be disposed of by the board through summary proceeding. Inquiry of serious offences shall be disposed of by the board by following the procedure for trial in summon case under the Code of Criminal Procedure. Inquiry of heinous offences. So, as I told you earlier, that this act divides all the offences into three categories depending on the punishment provided. So, heinous offenses, and there's a special category if a child is above 16 and below the age of 18 and has committed a heinous offense, then there's a special procedure should be adopted under this act in section 15. Section 15 says preliminary assessment into heinous offenses by board. So, in case of a heinous offense alleged to have been committed by a child who has completed or is above the age of 16 years, the board shall conduct a preliminary assessment with regard to his mental and physical capacity to commit such offense, ability to understand the consequences of the offense, and the circumstances in which he allegedly committed the offense, and may pass an order in accordance with the provision of subsection 3 of subsection 3 of section 18, provided that for such an assessment, the board may take the assistance of experienced psychologist or psychosocial worker or other experts. An explanation says that for this, the purpose of this section, it is clarified that preliminary assessment is not a trial, but it is to assess the capacity of such child to commit and understand the consequences of such alleged offense. So then again, uh, this assessment under this section shall be completed within the period specified in section 14. Like there's a period also prescribed. So now, uh, depending upon the result of preliminary assessment, the next proceedings जो है उसकी क्या होंगी. For example, preliminary assessment में आ जाता है कि the child does not attain the sufficient maturity, then the inquiry should be conducted by the board. And if it comes in the assessment report that he has attained sufficient maturity, he knew the consequences, understanding level is quite high, then his case should be referred to children's court. एंड चिल्ड्रंस कोर्ट क्या है, वो जो प्रोटेक्शन ऑफ चाइल्ड राइट के अंदर कॉन्स्टिट्यूट होती है या जो स्पेशल कोर्ट डेजिग्नेटेड है अंडर द पोक्सो, तो उसमें फिर उसका जो है प्रोसीडिंग्स वहां पे शुरू हो जाएगी. देन अगेन ऑर्डर्स जुवेनाइल के अगेंस्ट क्या पास हो सकता है और क्या ऑर्डर्स नहीं पास हो सकते, वो सब भी एक्ट में प्रोवाइड किया गया है. तो सेक्शन 18 में प्रोवाइड किया हुआ कि ऑर्डर्स रिगार्डिंग चाइल्ड फाइंड टू बी इन कॉन्फ्लिक्ट विद लॉ. सो इसमें द ब्यूटी ऑफ दिस सेक्शन इज दैट कि इंस्टीट्यूशनल पनिशमेंट को बिल्कुल लास्ट में रखा है ऑर्डर पास करते हुए. सबसे पहले, where a board is satisfied on inquiry that a child, irrespective of age, has committed a petty offense or a serious offense, or child below the age of 16 years has committed uh, or a child above the age of 16 years has committed a heinous offense, and the board has, after preliminary assessment under section 15, disposed of the matter, then notwithstanding anything contained, anything contrary contained in any other law for the time being in force, and based on the nature of offense, specific needs for supervision or intervention, circumstances as brought out in the social investigation report, and past conduct of the child, the board may, if it so thinks fit, first, allow the child to go home after advice or admonition by following appropriate inquiry and counseling to such child and to his parents or the guardian. Direct the child to participate in group counseling and similar activities. Order the child to perform community service under the supervision of an organization or institution. Order the child or parent or guardian of the child to pay fine provided that in case the child is working, it may be ensured that the provision of any labor law for the time being is not violated. Direct the child to be released on probation. Direct the child to released on probation of good conduct and supervision of any fit facility for ensuring the good behavior. Direct the child to be sent to a special home for such period not exceeding 3 years as it thinks fit for providing reformative services including education, skill development, counseling, behavior modification therapy, and psychiatric support during the period of stay in the special home. So, provided that if conduct and behavior of the child has been such that it would not be in the child's interest or in the interest of other children housed in a special home, the board may send such child to the place of safety. So, in apart from these orders, there are further additional orders may be passed that he may attend school, he may attend vocational training, he should attend a therapeutic center, and board may prohibit the child from visiting, frequenting, or appearing at a specified place, undergo a de-addiction program, and where the board, after preliminary assessment under Section 15, pass an order that there is a need for trial of the such child as an adult, then the board may order transfer of the trial of the case to the children's court, having jurisdiction to try such offences. So these are various orders passed by the board under Section 18. And now, if the child is sent to the children's court for trying as an adult, for the trial as an adult, then Section 19 defines the power of children's court after the receipt of preliminary assessment from the board under Section 15. There may be various situations. There is a first is there is a need for trial of the child as an adult as per the provision of CRPC and pass appropriate orders after trial subject to the provision of this section, and Section 21 considering the special needs of the child, the tenets of fair trial, and maintaining a child friendly atmosphere. Second, if the children's court thinks that there is no need for trial of the child as an adult and may conduct an inquiry as a board and pass appropriate orders in accordance with the provision of Section 18. And this is very important. Again, the children's court shall ensure that the final order with regard to a child in conflict with the law shall include an individual care plan for the rehabilitation of the child, including follow up by the probation officer or the district child protection unit or a social worker. The children's court shall ensure that the child who is found to be in conflict with law is sent to a place of safety till he attains the age of 21 years, and thereafter the person shall be transferred to a jail, and provided further that the reformative services, including educational service, skill development, alternative therapy, counseling, behavior modification therapy, shall be provided to the child during the period of his stay in the place of safety. Periodic follow up also suggested, and what if the child is released after the place of safety and he's not able to maintain himself? Then there's Section 20 also. It says child attained age of 20 years and yet to complete prescribed term of stay in place of safety. सो एंड आफ्टर दैट उसको जो है 3 साल तक के लिए भी स्टेट की तरफ से उसको फंड किया जाएगा, उसको जो है रिहैबिलिटेशन के लिए, रिफॉर्मेशन के लिए उसका आफ्टर केयर का भी प्रोविजन इसमें है. बट वन मोर थिंग दैट in any case that though is a preliminary assessment, he is sufficient, he has attained sufficient maturity, and he's been tried as an adult by in the children's court. Section 21 says that order that may not be passed against a child in conflict with law. No child in conflict with law shall be sentenced to death or for life imprisonment without the possibility of release for any such offense, either under the provision of this act or under the provision of Indian Penal Code or any other for the time being in force. So even after section 15's preliminary assessment and section 19 of the Children's Code, there's a prohibition under Section 21 that he should not be awarded death sentence or life imprisonment. And we all know that no joint proceedings of child in conflict with law and person not a child, एंड जो आपका सीआरपीसी का है प्रिवेंटिव डिटेंशन का, ये प्रोसीडिंग्स एप्लीकेबल नहीं होंगी. एंड the again, if we coming to the reformative approach and reintegration in the society, section 24 is important. It says removal of disqualification on the findings of an offense. So जिन भी केसेस में आपका पेटी ऑफेंसेस हैं, सीरियस ऑफेंसेस हैं, उसमें चाइल्ड इन कॉन्फ्लिक्ट विद लॉ का सारा रिकॉर्ड को इरेज करना है. बट हीनियस ऑफेंसेस में और स्पेशल केसेस में जरूरी नहीं है. Provision with respect of runaway child in conflict with law. So if a child is absconding from the special home, observation home, then no proceedings can be initiated against the juvenile. उसको फिर से लाके उसको observation home में या special home में भेज दिया जाएगा. So we talked about various principles, various category of offenses, various child categories in this act, and number of institutions. So if I can sum up my lecture or in the JJ Act, initially, child, it talks about child who is below the age of 18. Then there are various categories: child in need of care and protection, child in conflict with law, orphan child, abandoned child, surrendered child. So depending upon the category of that child, he or she shall be placed in various institutions. And what are those various institutions? There are, at times, there's like if we don't read it carefully, there may be a confusion that who is sent to observation home, special home क्या है, place of safety क्या है, then after care क्या है, और उसको जेल कब भेज सकते हैं. तो very simple criteria. If he is simple child in conflict with law, observation home. If he falls in the category of 16 to 18 plus committed heinous offenses, even during inquiry or after inquiry, he shall be placed in place of safety. Right? And when at the age of commission of crime, he was juvenile, but he's no longer juvenile when he's apprehended by police authorities, then for the purpose of inquiry, he shall be treated as a juvenile, but he shall be placed in place of safety. And if during place of safety also, his sentence remains that up to 21 years, he shall be kept in place of safety. After that, he can be sent to jail. Now, coming to the various institutions, there is a mandatory, registration of these institutions. And if we read the rules, uh, rules provides everything that right from the cleanliness, hygiene, schooling, vocational training, and कितना उसको उनको डाइट मिलेगा, कैसा बेड होगा, क्या क्या उनके ग्रीवेंसेस होंगे, उनको कैसे रिड्रेस किया जाएगा. मतलब they are so elaborate. If you read all these rules, so it takes care of all the all the aspects of which we say के right to life and liberty को protect करने के लिए, reformation के लिए, reintegration के लिए, but again रियलिटी और एक्चुअल उसमें थोड़ा सा फर्क होता ही है, कितना सक्सेसफुल हुए हैं ये इंस्टीट्यूशंस. सो आई थिंक बहुत सारे इंस्टीट्यूशंस में जो प्रॉपर जो स्टाफ है वो नहीं है, बच्चे अपना खाना खुद ही बनाते हैं और उनको वोकेशनल ट्रेनिंग इस टाइप का कोई बहुत ज्यादा नहीं है. लेकिन ये एक्ट अपने आप में बहुत बहुत खूबसूरत है, बहुत इसमें जो है बेसिक प्रिंसिपल्स बताए गए हैं, सेंसिटिविटी बहुत ज्यादा है चाइल्ड के प्रति, एंड इंस्टीट्यूशनलाइज्ड उसको अप्रोच को बहुत बहुत ध्यान में रखा है कि उसको बिल्कुल एज ए लास्ट रिजॉर्ट ही उसको हमने देखना है. सो अब अगर किसी का कोई क्वेश्चन आंसर्स हो तो हम लोग उसको डिस्कस कर सकते हैं अभी भी, क्योंकि वैसे तो मैंने कैटेगरी किसके हिसाब से बता दिया उसको किस किस इंस्टीट्यूशन में भेजा जाएगा, बट फिर भी अगर कोई क्वेरी है तो हम लोग डिस्कस कर सकते हैं.
हम बार बार जिक्र कर रहे थे चाइल्ड इन कॉन्फ्लिक्ट विद लॉ, तो एक सिंपल लैंग्वेज में किसी को समझाना हो तो इसका क्या अर्थ रहेगा?
इसका अर्थ है कि वो अभी तो जुवेनाइल ही है, 18 से कम का है, बट उसने कोई अपराध उससे हो गया है, तो बोर्ड के द्वारा उसकी इंक्वायरी तो होगी ही कि क्या उसने ऐसा किया है या नहीं किया. आई थिंक दिस इज द सिंपलेस्ट डेफिनेशन.
Yeah. And then it says, what does the juvenile justice system mean by a reformative approach, and how it is distinct from the custodial or punitive?
विकास जी, जैसे बहुत सारे सेक्शंस में हमने देखा कि द मोमेंट जुवेनाइल इज apprehended, right? So there's a provision for special juvenile unit in every state, a child welfare officer also, and at times there he may be a child in conflict with law, and at that same time is often abandoned or surrendered children. He's child in need of care and protection. Then it's become the duty of the special juvenile police unit to contact the child welfare officer, and the child should be placed before the child welfare committee, and it has extensive role to play in the reformation of the system, because ये तो हम सभी को पता है कि इसको हम लॉकअप में नहीं रख सकते. देयर स्पेशल बार, पुलिस यूनिफॉर्म में उसके सामने नहीं आएगी, हैंड कफिंग नहीं होगी, और तो और जो कुछ एक एक्सेप्शनल सर्कमस्टांसेस में सिचुएशन में ही एफआईआर दर्ज हो जाती है, नहीं तो हम एसआईआर ही बोलते हैं, सोशल इन्वेस्टिगेशन रिपोर्ट, जो उसकी बैकग्राउंड उसका सारा चेक करके जो है बोर्ड के सामने उसको लेके आते हैं. आई थिंक इट द एक्ट इटसेल्फ इज वेरी इलैबोरेट.
Next is, are inspection, social audits, and monitoring mechanism
Yes.
meaningful or merely more procedural?
पॉलिटिकली करेक्ट आंसर, और आई थिंक एक्ट में तो बहुत डिटेल्ड है, और जो मैंने देखा भी है, वुमेन एंड चाइल्ड डेवलपमेंट डिपार्टमेंट उनके साथ काम भी किया है, और हमने एक बार मेरी एक एनजीओ है उसके साथ मिलके हमने एक सोशल ऑडिट रिपोर्ट भी तैयार की थी. वी विजिटेड ऑल द चाइल्ड केयर इंस्टीट्यूशंस इंक्लूडिंग ऑब्जर्वेशन होम, स्पेशल होम, और हम वी मेड फ्यू रिकमेंडेशंस ऑल्सो, बट अभी वो पेपर पे ही है. इसमें एक और मुझे जो फ्लॉ थोड़ा सा लगता है, एज पर सेक्शन 15 जो प्रिलिमिनरी असेसमेंट की बात करते हैं, तो वी नीड हाईली ट्रेन्ड psychologist for that, and board that is not being taken care of.
That I think even in mediation where the divorces and the child custody is required, for that
yes.
also good psychologist and
नहीं है वो. और ये हमने जब सोशल इम्पैक्ट असेसमेंट इनका किया था, तो देयर वाज ओनली वन psychologist who was attending Ambala also, Sonipat also, Faridabad also. So that was not as per the spirit of the act.
कई सॉफ्ट स्किल्स की इंप्रूवमेंट हर डोमेन में जरूरत है.
नहीं है वहां पे. एंड वन मोर थिंग इज दैट द एक्ट सेज दैट वुमेन एंड चाइल्ड डेवलपमेंट डिपार्टमेंट से जो जेल ऑफिसर्स या उन सबको नहीं रखा जाए, लेकिन वहां पे जितने भी चाइल्ड केयर इंस्टीट्यूशंस हैं वो रिटायर्ड जेल अथॉरिटीज को इन्होंने री एम्प्लॉयमेंट दिया हुआ है, which is against the spirit of this act.
How does the preliminary assessment for 16 to 18 years old diluted the reformative ethos of the juvenile justice?
I didn't get the question.
कि भाई जो preliminary assessment होती है 16 to 18 years वाली,
जी.
तो how has that been diluted the reformative ethos of the juvenile justice system?
No, it's not diluted, because if you know that why this section 15 came into force after the Nirbhaya Kand, because there was no categorization, no categories of such type of juvenile 16 to 18. There was a specific amendment after the Nirbhaya Kand, and it is need of the hour that, considering the age of age and understanding level of the juvenile, that the preliminary inquiry should be conducted, and he requires different treatment. But again, there's a section 21 also, that he should not be sentenced to death or life imprisonment. He should be sent to place of safety, and various orders should be passed, because the main object of this act to reformation only.
Last question. This would be a personal take, since you're also running an NGO. Is the juvenile justice system protecting the society from children or protecting children from society?
I think it's both. बट अगेन, जैसे एक मैंने मूवी देखी थी, आई जस्ट कांट रिमेम्बर, ग्रीन माइल. एवरीवन शुड वॉच दैट मूवी. उसमें उसका मोटो यही था, कैच देम यंग.
इनफैक्ट हिंदी मूवी कालिया में भी था कि अगर
हाँ
अंदर
जी.
रहता है तो whether he will become a hardened criminal or we have to.
Yes.
It's a balancing act of a question. Yeah.
तो अगेन इसमें ध्यान रखा ही गया है ना, अगर कोई उसकी थोड़ा सा भी 16 और 18 की कैटेगरी है और बड़ा हो गया, तो उसको ऑब्जर्वेशन या स्पेशल होम में नहीं रखेंगे, प्लेस ऑफ सेफ्टी एक अलग से ही बना दिया गया है. और अगर बेल भी इसको नहीं देनी है, तो वो भी इसलिए कि इसको हार्डन क्रिमिनल के कांटेक्ट में ना आए. तो इट्स बोथ, सोसाइटी को भी प्रोटेक्ट करना है और बच्चों को भी प्रोटेक्ट करना है.
So thank you. And tomorrow we will have a session on judicial services examination preparations, tools and techniques by a former district judge from Delhi, Mr. Manmohan, and he has already done various sessions with us. Do join us tomorrow at 6 p.m. And thank you, Dr. Deepa. It was such a pleasure connecting with you. Thank you.
Thank you so much.